Mm, 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 mm. Let's see. Mm-hmm. 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 La da doo. Danny boy, the pipes are calling. Angela, what's going on, Angela? What's happening, Angela? What's going on, Bookie Boo Boo? B. Lewis, hey, it's me again. I'm back. I'm back again. Jillian, hello. Howdy do. Marilyn, nice and early. Look at you, honey. Ooh, ooh, ooh. No, Mama late as balls. Mama procrastinated the maximum amount. Mama procrastinated so much that she left the house. I couldn't procrastinate quite enough here. So I left the house, went to the grocery store, and bought a random ass pumpkin pie. That's that's how much I was procrastinating. I was supposed to push the button to start this live stream. I was supposed to push the button instead. I put my shoes on and went and bought a pumpkin pie. That's what I did. It's deep. It's that deep. Well, I see, is my ceiling fan on? Got hot all of a sudden. Mm-mm. Ooh. Mm. Easy Duke. What's up? I finally got a live. Yes, you did. 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 You're here. And we're very happy about this. This is great news. It's great news, it is. Congratulations to us all. It's the last of the month. It's the last day of the month. Ooh. Dun, 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 dun. Ooh, let's see. Let's do all of our little things. Oh. Daryl was settling in. Trial day 14 when he's just, waiting for them to tell him about this 3,000-year sentence. He about to start out, his new relationship with Bubba. Oh, I have so many stalls to share. Oh. Is it like when you buy those, can you only buy like you bought a bunch of stars? Or you bought a bunch of rubies and you just picked stars? Like, cause I thought it was like you buy a bunch of rubies and then you can buy little thingies with it. You say you just bought a bunch of stars? Cause they're like 2 cents, 2 cents each. So I don't really understand exactly how that works. Ooh, 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 ooh. What? You're almost a brat. Oh my God. I've never seen a pregnant bird before. Marilyn says she is about to be a bird grandma. I've never seen, I don't even know what that looks like. I'm looking forward to opening this up and looking to see what that looks like. We need to find out what a pregnant bird looks like. I need to know. It's just what I need to know. Mm. Mm-mm. La da dee, la da doo, la da dum. La da dee, la da doo, la da dum. She laid her first egg. Oh, that's right. Birds lay eggs, don't they? I forgot. I forgot about that. So she already laid the eggs though. So they're not. Oh, that's right. Okay. Once a bird lays egg, does the egg grow Or is the egg just stay the same size that it comes out of the bird until it cracks? Teach me the bird reproductive process. 2 cents each, and I think I spent $9.99 on them. I bought the galaxy of 2 cent, a galaxy of 2 cent stars. Oh, is that how it worked? Oh. Oh. Mm. Mm, 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 mm. So I guess that means a galaxy must be $10. So galaxies must be worth $10, and I guess, or 5 or something. I don't know. I don't know. Oh, let me push this button. Mama got distracted again. Mama got distracted. It's very easy for that to happen. I'm going to tell you something that I love. My new schedule started, which means I don't have to go to work tomorrow. I'm so happy. I'm so happy. I'm so happy, happy, happy. Ooh, ooh. Ooh, thank you, Rebecca. Mama got some coins. Ooh. Mama got a coin. Mama got a gold coin. Nice. Thank you. Cute. What was I doing? What was I doing? Oh, yeah. Oh, yeah. Hit the like button. Hit the like button for Mama. Oh, good. It popped right up. Okay. Do this. Do that. Copy that. Bam. Nailed it. Paste that there like so. Push that button. And pin it. Nice. 'Cause you good as gold. Oh, thank you, baby. Mama appreciate you. Ooh. Rebecca said I'm good as gold, y'all. It is what it is. It is what it is. It is what it is. Okay. I'll go ahead and start this thing up, and I'm going to text my Sammy Sam. Darrell's looking up at the stars. What's that old Disney song? Where they say, are we looking at the same stars tonight or something? Is it somewhere out there? Is that the song? Where they say something about are we looking at the same stars or something like that? Either that or Darrell found a spider web. One of those two things is happening. Ooh.
That's from yesterday too. You gotta scan that in too. Okay. And then, do you have the sheets for me? From
Second star of the night.
The yellow, his yellow sheets.
Yes.
Somewhere out there.
Isn't there a fourth one?
There's more.
Somewhere out there.
Yeah.
Someone saying a prayer.
All right, it's 2:00. I'll call the case. State of Wisconsin versus Darrell Brooks. Case number 21 CF 1848. May I have the appearances, please.
Good afternoon, Judge Sue Arthur, Leslie Daisy, and Zach Wichow appearing for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion, judiciary.
Not the extortion.
This is a social security, sesquique, trust action which you are a real party and interest to, as sui juris and propria persona. This is a military, admiralty, tribunal, and maritime law.
All right.
Under Title 4 of the United States Code, Section 1.
Sounds terrible.
which you can see, which states placing of fringe on the national flag is within discretion of president acting as.
I see a little egg. Look at the egg, y'all. Look, she got an egg. It's over here. It's like right there. Can y'all see it? It's like, see it on the bottom? That's her grandbaby. Look, y'all. That's Marilyn's grandbaby. See that egg? That's Marilyn's grandbaby. Oh, how cute. How adorbs. Hey, cats and dogs, been a minute. What's been going on with you? Yes, we are. We're making fun of Darrell. You know what I'm saying? Good times.
Commander-in-Chief of the Army and Navy. Is this a common law court or an admiralty court?
Admiralty. We're on the ocean, Darrell.
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless. I would also say the same as to the
LaShonda, hey boo.
Notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor.
With all respect, Your Honor.
We still have yet to address subject matter jurisdiction, which has yet to be proven on the record.
These. No, where?
May I receive those original copies time-stamped?
Okay. All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that, and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties.
Am I saying it right?
We missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's...
I accept the value in return for value of this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
You know what? Well, I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the event book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments, are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you...
As we can tell by Darrell's eyes being in a constant state of rolliness, he's going to respect that, Your Honor. He's going to respect your wishes. Ooh, Mama got some more gold coins. What? Ooh, Mama got some gold coins. Yes, she did. Oh, you know what I just thought of? See how they say how much they are? See how they say for 10 jewels? I wonder if did the stars say that when you sent the stars, Marianne? I wonder. Did they say? Remember, we went and looked it all up. Like was it just sitting there the whole time? I don't think so. I don't remember it saying when you sent the stars. I don't remember it.
You are stating is not proper under the various rules and case law that govern
Mama before
closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right.
And I don't have to work
with that,
tomorrow.
I will have the jury. Oh, go ahead.
Because of my new schedule.
Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's going to put it like right here. And then you want me standing at this table during
I do.
Yes. So I would just position it like right here.
Button too. Let me.
And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom.
Let me get some red emojis in the chat. You know what I'm saying? Ooh, red emojis in the chat. Ooh, I gotta go con. I gotta go con. Thank you, Mama. I appreciate you. Yes, you do. Ooh.
Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what
as
I was going to put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection. What is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but I'm
In terms
saying
of-
I don't understand what what's being shown. Should not
Hey,
have the right
Jessica.
to ask, to object and ask
No.
what it is
Nope.
that's actually going to be shown.
Nope, no rights.
The state's put on the record what it is. It's a
No rights
It is they, or I should say, they are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing argument. So
I'm making a request, the same request. May I be able to put up
well, I guess
exhibits?
it depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is once the state goes through its closing, I may take just a short comfort break.
What y'all think his exhibits would have been? You know it's some shit he got no business bringing in there. What y'all think it would have been? Nothing? Exactly. That's exactly what it would have been. Nothing. It would have been nothing. He asking this question for shits and for giggles. He didn't even have anything to show. It's all about principle with Darrell. It's all about the principle.
Right, depending on how long it is. And if there's something in particular, what are you will need to tell me what it is. As long as it's an
Nice.
exhibit from this case,
Y'all is coming through with the red
then
emojis.
I wouldn't have an issue with it.
I like that. I like
They
that.
would be from this case,
I like keep
obviously.
it coming.
It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial
Look at Darrell.
as an exhibit by the court,
Look how he ain't moving and he ain't
unless you
blinking.
tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
He gonna
They're,
will something to happen. By
Part of my
staring.
filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your
Little
arguments,
Woody's top
so that
50
when they
moments.
go back to determine the issues in this
From
case, which
YSL.
are related
Oh,
to
yeah, Woody was
whether you're
hilarious.
guilty or not guilty of the 76 charges. Things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings that
That's
was
not
filed.
specific enough, sir. What are you
My
referring
court
to?
docket
Which
sheet.
filing?
Let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done? Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
Which?
Look at him. He's like,
what
ah.
file
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
That is the lamest form of gaslighting because everybody knows that that's a gaslighting thing. Are you done? Everybody knows that. It's like a terrible one to just pretend like, what? I was asking you if you were finished. I was being polite. I was trying to be considerate. And I didn't want to interrupt you. So I just said, are you done? Are you done? You know. It was out of politeness, Your Honor, Your Majesty, Your Highness. Look at it. And that's why you under the prison, Darrell. I hope it was worth it. Was it worth it? Who's this man right here? Hoppo. Who this woman? Who this? I don't remember ever seeing this guy. Am I alone in that? Does anybody? This guy look familiar to y'all? I don't recall ever seeing this man before. It's my first time noticing him. He want to be smart and difficult. Yeah, he do. He want to feel in control of something. He's scraping for it. And he never got it.
I've asked a question, sir. So when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
Saying,
All
With
my
specifics.
filings,
Hey,
my
boo. Yeah, mama back.
my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks, you
explain
are
why
not
that's
going
not
to
relevant?
be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth and their duties and their rights. They
Yeah,
should know
they
that
should
at
know the
least.
truth and their duties
Mr.
and
Brooks,
their
I'm
rights,
putting you on
et cetera.
notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to
So
you.
they can't even know that I got a shock device on my ankles?
They absolutely do not need to know that.
Why
so it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
I will argue that it
your
is.
conduct from November 21st of 2021 is what
That
is
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay.
It's my constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which I
you're-
preserved my First
so
Amendment
you're
right
done?
when I came in this morning. I also preserved my
All right,
Sixth
Mr. Brooks,
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is
Brooks,
the law
I
of the
direct your
land.
attention to closing instruction 460.
I'm
which will
going.
be
I'm
read
going
the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights under the First Amendment and under the Sixth Amendment.
You tell
I
'em.
have the right to inform them of their rights, of the truth, and of their duties under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't. No state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
not-
they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved, the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also
Not null and invoid. That sounds like the opposite of what you wanted to mean, Daryl. Invoid sounds like it would be like not void. So not voided, which means still applying or relevant. Applicable.
forfeit by your conduct the right to present a closing argument. In appropriate circumstances,
The particulars.
the right to present a
Particulars,
closing
Dillian.
argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. the goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation, and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and
hit the
of
like button
course,
for mama.
last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty. All of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless.
My name is what? My name is who? My name is Lil Emotional. There'll be a little motion. I'm a little emotional. That's all.
They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote,
snatch her ass up.
It does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows. And that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence.
It's about to explode.
It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury.
Mama ain't tired. Mama is wide awake, honey. Mama ain't got to go to work tomorrow. Mama ain't got to go work tomorrow. Mama ain't got to go work tomorrow. Mama ain't got to work tomorrow. Mama ain't got to go to work tomorrow. Mama ain't got to work tomorrow. Mama up. Mama up. Mama up. Mama up. Oh. I'm probably going to be up like late tonight because it's, just to maximize the weekend, the long weekend that I now get constantly, since now I don't work on Mondays, so I get 3-day weekends. Ow, 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 hey. No, I'm not tired. I was just looking up something. I got like a bunch of different boards on my screen. I got a bunch of different screens up. I got 1, 2, 3, 4, 5. I got 5 windows open, on two screens. Mama's doing her version of multitasking. She ain't good at it, so we'll see how I go.
Out to complete the instructions that I need to complete to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you.
I let you make your record.
Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. I'm not
allowed to make
required
the
to give
record
you that
at all, Your
opportunity,
Honor?
sir.
I'm not allowed to make the record at all?
Nope.
As I just let you did, because some of the issues
told me what you want to do. I've told you can't. I've addressed the request.
Some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing.
Mr.
As far as your rulings.
Once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if convicted, to raise every issue.
Contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether he agrees with them or not.
I haven't dishonored the court. I'm merely
I ain't
exercising
dishonored
my
this court.
rights
I ain't never
under
did
the
nothing.
Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm not
the way that you have through
disrupting
the
the
course
proceedings.
of
You just told me you
Santana.
don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury.
asking
I'm informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you
present.
to be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
record
satisfaction. It's
has
about the
been
Constitution. It's about what's right.
Are you going to
Are you
follow
going to
the
answer
court's
questions as a public
requirement?
servant on why you're making up laws
Nope.
that are not in the Illinois versus Allen? It never utilized
the
the
jury
mute button.
can
It
go
never
back
said
to the
anything
jury
about a
room.
mute
Thank
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not?
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant-
invite you back
Nope.
over when it's time for your
You can't
closing
invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other courtroom when I can
and you'll
do
mute
so
me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my First Amendment right.
Yeah, y'all can't be trampling over Darrell's rights. It's just not fair, Your Honor. It's not right. You need to not do that to the Darrell. He's very sensitive about his rights that he mysteriously has, considering the fact that he's a sovereign citizen, according to him. So, the contradiction is confusing. Is it? It is. It is. But so be it. You know what I'm saying? Oh. Hey, Tamara. He's having a tantrum because they're about to give him 2,000 years for driving over the children in the parade. He's pretty upset about it. He's pretty sensitive about it, Tamara. He said, y'all need to listen to me. I know what I'm talking about. He like, what's going on with my monitor, my computer? Yeah. Look at him. Poor thing. Oh, he misses his homesick. He's homesick for those cars those abandoned cars he used to sleep in. He misses it. He misses his home. I think he is. He really does actually think he's stopping something. That's the funny part. He thinks he's stopping something. Okay.
He was insistent on
pants
raising a variety of legal issues with
Okay.
which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we are in a court proceeding and a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways.
Thanks for holding my spot for me, Darrell. I appreciate you. You know what I'm saying? For holding down the live stream while Mama went and made some delicious, wonderful, fascinating coffee. Oh. Did y'all see me dance? Darrell had to, hold down the live stream, while Mama went and made some coffee. He had to fill in for me, make himself useful. You know what I'm saying? Because he's useless.
To handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his.
I didn't notice this, but this is the same outfit Darrell's wearing on this day. Look. Darrell, look. Look, it's you. It's you. With moo-moo on your forehead. It's you. I just noticed that.
His courtroom, however, it is set to 1 camera since he's the only individual there.
Hey, Joseph.
Other than the bailiffs, but I'm talking about as a party to the litigation. So The courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle. And she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and
He looked like somebody at a concert about to start, like one of those little groups, and they about to start singing, and they start turning around. They, like the Temptations or some shit. They always start like that with their hands behind the back and with the head tipped down, and all of a sudden they spin around. One in the chat if you know what I'm talking about. One in the chat if you know exactly what I'm talking about.
And decorum, that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection.
Yeah, Arsenio Hall. Arsenio Hall definitely used to do that. He definitely did. Rick, he definitely did that. That's hilarious.
Objection, I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Your Honor, two quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head. They've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust
Sure.
accordingly.
Okay.
Hey, Daryl. How you feeling about yourself? Are you feeling successful? You looking at my jar? Yeah, it's empty. So what? My jar is taller than you are, Daryl. That's how little you are. Little. Put Daryl in the jar. Daryl, how you feeling? Looking at a little jarish. Why is he acting like he's having a
The
regular
record
conversation?
should reflect that Mr. Brooks is now present in the main courtroom. Prior to reopening following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
Yeah, you ready?
Ready to address subject matter
I want to
jurisdiction
hear your
as
closing
well, too.
argument, Daryl.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the
Jillian.
jury out. Are you prepared to present?
Nice. Thank you, Jillian. Ooh, Mama got a member. Yes, she did. Yes, she did. Got Oh, look. You see that? That's what happens when I get a member. The little chibi. The little chibi went into the jar. That's what that is. I said it for those. But when I get a new member, a little chibi emoji falls in there. Imagine if I could fill this thing up. That would be all members. Oh, fascinating. Ooh, we got a gifted. We got a gifted member from DSB. And, oh, look, and the Panthers got it. Well spent, DSB. Thank you, baby. Mama, appreciate you. Oh, gifted ones. I don't think gifted ones count. I don't think gifted ones will fall in there. It's only individual ones fall into the little jar thing. But thank you, baby. Mama, appreciate you. Yes, you do. Ooh. Yes, Mama need to get her memberships up. It's steady dropping. It's just dropping. They dropping like flies. Ooh. Thank you so much. So very much. Oh, nice, Jamie. Nice. Another good one. I love when my consistency babies, get gifted members. It's always nice. It's always nice. It's wonderful. It's awesome. It's awesome sauce. Thank you, baby. So you're always welcome, my warrior sister. Yes. Wakanda forever. Yes. Nice.
Your closing argument.
I would like for you to prove subject matter jurisdiction on the record. Your
Yeah,
Honor.
prove it. That's right. You
I'm
tell
not
it,
addressing
girl.
that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to
The
ask
like
you
button.
one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There is no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of you said written decision?
Oh, Marilyn says she met the lead singer from the Temptations. Which one's the lead singer, Marilyn? But to look that up real quick.
Sir, my written decision has been filed into the record.
Lead singer.
That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've
Is it
indicated
David
that
Ruffin?
in my written decision
Is
as
it
to
David
why there
Ruffin,
is
Maryland?
subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to...
I accept for value in return for value this document, as it is not based in lawful law, and it does not prove.
That's not from the Temptations. Ain't nobody come to see you, Otis. That's from the 5 Heartbeats. You talking about the 5 Heartbeats, Jessica? Not Jessica. Sorry, Miss Santana. That's from the 5 Heartbeats. That's not a real group. That's a pretend group based on kind of like the Temptations. Oh yeah, Connie. Yeah, Connie. That's what I. He's very famous, but my mind went blank. I'm pretty sure that is David Ruffin. When I put in lead singer, David Ruffin is the name that pops up for everything. I put lead singer of Temptations, and everything is pointing me at him. David Ruffin is the main one. He wore glasses. Did he wear glasses? I think you were. I'm pretty sure that's what it is. Yeah, Leon. Yeah, that's from the 5 Heartbeats. That's a fictional group. That's not a real group, I don't think. Y'all correct me if I'm wrong. I'm pretty sure that the 5 Heartbeats is like, it's because it was a movie. I'm pretty sure that that's like a fake group. That's not like that wasn't like a real group or anything, right? I mean, they weren't based on, like, there's not a real group that was called that, right? The Platters are the OG. Oh my God, the Platters. You know, them people, I wonder how much money they used to make back then. Because, you know, they would have those horrible deals. And then, so I think they would be broke and stuff. But then they would live in kind of sort of nice houses as long as they didn't get on drugs. Which seemed like it happened a lot. Oh, it was a fake group. I thought so, Miss Santana. I love how we just go down like rabbit holes just randomly. It's so us to do that.
Subject matter jurisdiction whatsoever.
Just go down
Refers
side
to
quests.
Some complaint that was filed in the name of a trust, not my name.
The Sesti? Is
Were
it
you
the
aware of that,
Sesti Trust? Is it the Sesti?
Mr. Brooks, the jury has been asked to be brought
I'll
out.
look that up and see what it
I
says. Sesti
requested
Trust.
that they be brought out.
I don't know how
They're
to
on their
spell
way.
it, but-
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All rise.
So that is a tacit agreement.
Record to reflect the jury is coming out.
Hey, you guys, I'm trying to look up that Sesti Trust that he keeps talking about. But how do you spell whatever that word is? I looked up Sesti. I looked up Susty. What's the word he's saying, that Sesti Trust? What can y'all... What's that word? I want to look it up. Or you gotta run out. Okay. All right, Nepenthes. Sesti. Yeah, we'll be here. Pretty sure we'll be here in the Panthers.
Thank you, everyone. Please be seated.
There's the...
Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
Sir, this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr. Brooks, this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read.
Did you inform
They will be informed of the law.
Did you inform them that they?
And I got the spinners. I got the OJs. Gladys Knight and the Pips. Oh, bird time. Okay. And the Delphonics. And the Stylistics. They was wild with the names, wasn't they? They was wild. Oh, Marvin Gaye. The Commodores. The Commodores was the one that Lionel Richie was in. Yeah. There we go. SDQ Trust. Okay, thank you. I'm gonna look that up.
They can nullify the law?
Mr. Brooks, you do not have that right to request that. And I'm advising you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr. Brooks, you have no right to make that argument to the jury.
It's true. They have the power.
All right. I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
See how he said it so calmly? He said it so I will. Oh, I'm about to, Your Honor. I just want to make sure that the jury is aware of this, that they have the power to just decide to let me go if they wanted to. I just want to make sure that they're aware that if they wanted to, they could just open the door and, cut this, like release me from being attached to this table like I am, and they could just free me. And I would run out of here with my kinkles and slides. With my kinkles and my slides, and my white socks and my slides, and my blue Bible, and my red pointless folder. Ooh. Let's see. A SDQ Trust, pronounced STK. Oh, STK Trust. Oh, he ain't even saying it right. He would say SDQ. It's SDK. That's how you pronounce it is STK. So it's STK. He ain't even saying it right. Is an archaic legal term for a beneficiary of a trust. It refers to the person who possesses the equitable right to property and receives the benefits, such as income, interest, or profits from assets held by a trustee. Okay. The term comes from old French and means the one who trusts. Key aspects of the SDK Trust: equitable title, modern terminology, rights, and protection. Surprised they don't just mention, because the only time you really ever hear people talking about this is when it's a sovereign citizen saying something crazy. Oh, let's see what this is.
I know for certain that me not being born into like a trust fund family, into generational wealth, is a mistake, because I can tell by the way I spend money. It's not hard to see I spend money like a person who has a trust fund, but the funny thing about that is I don't have any money. I don't have a trust. I don't have nothing.
Oh my God. I don't know why she felt the need to share that. Some people just that's what they say though. They say, just push record. Sometimes people just shouldn't. Thought she was going to teach me something. Like, I could have swore. I was like, oh, she's going to explain something to me. I click this button. She's just sitting in the car drinking oat milk, talking about nothing at all. That was terrible. I had to take a phone. Okay. Okay, no problem. Hey, Gino. It's a fictional word. No, it's a real word. They just use it for some weird purpose. Oh, Smokey Robinson and the the Miracles. Yeah. The Penguins. What the fuck? I ain't never. You made that up. You made that up, Patchouli. You made that up. That's not real. Hey, C Cantu. What's up? How you doing? How you doing? Yes, honey. Ooh. Y'all hit the like button? Did you do it? Hey, Liz, Smokey Robinson and the Miracles. Well, he think he did something. Look at him. He all proud now. Look at him. Look how he keep cutting his eyes over there. He think he done did something, y'all. He's like, that's right. We can't finish this because I'm going to keep saying that thing that I'm not supposed to say. So, ain't nothing we can do, I guess. We're at an impasse. All right, Daryl. All right. Hey, Harley.
Thank you. Please be seated.
Harley, what's going on?
Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for.
Oh, Earth Angel, would you be mine, my darling dear, love me all the time. I'm just a fool in love with you. Apparently that's the Penguins. Wow. Oh shit, I didn't even think that was real. Turns out I knew one of their songs. Ain't that something? Earth Angel, would you be mine? Oh my gosh. Oh my God. I thought they were white. In my mind, that song is sung by some white boys. In my mind, that's white boys singing that song. I just looked up the photos, and I was like, "Oh shit!" Well, oops. My brain deceived me again. I just knew they were some white boys. I was like, "Let me see what they look like. Let me see these." I was like, "Oh shit, nope." A fool in love. Yeah.
For that reason, you may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom. I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both
That's right. You tell 'em,
that
Darrell.
decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not prepared to
be
make
able
that
testify
ruling
to.
here yet today, but I will tell you this, sir. The time has now
Cool in the
come
gang.
for you to present a closing argument.
I think that's a rap group. Isn't Cool in the Gang is a rap group, I'm pretty sure. We're naming like doo-woppy like type groups. You know, the types of groups where they'd be like, they'd be like da 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 do 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 do. That kind of groups. You know what I'm saying? That's what we talking about. You know, not rap groups. Not like Jodeci. Or no, that's an R&B group. The kind that dance. They dance with microphones. Them kind. We were listing those from the 70s. The ones from like the 70s time frame. Cool in the Gang, I'm pretty sure. Cool in the Gang is a rap group, is it not? Let me know if I'm wrong about that. I feel like Cool in the Gang is a rap group. I dropped a glass pitcher on my foot and it was cut back. What? Oh, a glass pitcher. Oh, like a lemon, like a. Oh shit! Ooh, it is shattered. Honey, that sounds terrible, Jamie. That sounds awful. I want no parts of that. That sounds terrible. No, not disco. You sure? I thought Cool in the Gang was a rap group. No. Let me look that up and see who Cool in the Gang is. Cool in the Gang.
There will be no further delays. I will not be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing argument.
Nobody said the Jackson 5.
It is
Violating
up-
my constitutional
Sir,
right.
please don't
Oh, we
interrupt
missed
me.
the
You've
Jackson
now
Five.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Oh.
Okay, now you can say
So, Mr. Brooks, I'm advising you yet again. The
I
time
don't
has now
consent to
come.
being called
That's
that
another
name, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were brought back
Okay,
over
I think
to
Cool in
this
the Gang
courtroom
they
for
might
that
count.
purpose.
I'm going to let them
That's
know.
another
Yeah, it looks like Cool in the Gang counts. They count. Because it's like a bunch of them, even though some of them hold. Ooh, got me another member. Well, re-up member. Lady fucking T. Thank you, baby. Mama appreciate you. Yes, you do. Ooh. Yeah, so probably Cool in the Gang is like, you know, they play instruments though. So they're not just standing there with the little mic thing, but I guess they count. I guess they would count too. I gotta look and see what they sing. I don't. Well, let me just click this. I can just see what's the name of one of these songs. La da 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 dun 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 Bantios. That's where they be fresh. Oh, celebrate good times. Come on. We're gonna have a good time tonight. Ooh, a celebration. All right. Summer Madness. I don't know how that go. Ladies' night. Hollywood swinging. Oh shit. Da, 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 da. Yeah. Okay. Yeah, the Commodores. Remember the Commodores? That's yeah, we called that. That's Lionel Richie. Mm-hmm. Ladies' night. Yeah, they got a ladies' night. Is that the one like this is ladies' night? Is it that one? Yeah, that Hollywood swinging though. That's a big one. That's still now, you know. James Warren Taylor. That's so funny. Like,
Interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me trying to give.
Are you telling me, sir, that you are going to give? Let me ask you a question.
Hold on. I'm not trying to give any
sir,
jury
you're interrupting me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
Yeah,
that's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm going to inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have it. You just said on the record that they have the power for.
Sir, I direct your attention.
You just said that. Did you not just say that, Your Honor?
Sir,
you said I couldn't instruct them.
The jury has the power, but not the right to nullify.
Right. You said the power. You said the
power. Listen to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
that you are going to disregard? I just told you what you just said.
My directive to you to not raise the issue of jury.
Oh, thank you, Bossy Tuba. It's looking like it's a night of memberships. It's looking like that's what it is. We're having like a bit of a trend here of memberships. You know what I'm saying? That seems like what it is. That's nice. That's nice. My memberships are terrible right now. Thank you. Thank you, Bossy Tuba. Let's see. Patchouli got one. Beach Girl, Starseed, D. Sanders, Irene. Thank you very much. Yes, honey. Everybody say thank you, Bossy Tuba. Thank you, thank you, thank you, Bossy Tuba. Thank you, thank you. Y'all know it's the 31st. You know what I'm saying? It's the last day of the month. It's the push. It's the last push. It's the last push. You know what I'm saying? For my little month of May check. My little month of May YouTube check. You know what I'm saying? It's the 31st push. I got 45 minutes left for the day. Oh.
Nullification during your closing argument.
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkus says, and stands for the proposition that although the jury has the power of jury nullification,
they have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I just want them to be informed. I just want them merely to be informed. That's it.
You can call it informing, making them aware.
Yeah, they should be aware of the rights.
You are not allowed to make them aware of their power to nullify. That is an improper argument.
Your Honor, how can I not inform them that they have a power? How can I not inform them of a power that they have? I'm not giving a new jury instruction. That's not what I'm arguing.
There is no jury instruction for jury nullification, because it's not allowed.
I'm not attempting to give them a new jury.
Darrell said, look, Your Honor, this isn't right. It's not right, though, Your Honor, because they have this right. And you know me, I like to do the right thing, Your Honor. You know, I'm all about the right thing. You know, that's why I'm a great father who could definitely pick my children out in a lineup. I definitely only knock up people once they're of age. I mean, I'm known for that, if nothing else. You know what I'm saying? I ever, impregnated a child. I've never done that. Not who I am, Your Honor. Not who I am. And right now, this jury, they need to know this thing. How can you expect for me, being the wonderful man of honor that I am, to not inform this jury of their rights? I mean, this is craziness. Look at this. Oh my God, Darrell. I'm embarrassed for you, Darrell. I'm embarrassed for you. Okay, this is embarrassing. I'm embarrassed. Look at this man's face. Exactly, sir. That's how I feel. The way that this man's face is doing is how I feel about this.
Instruction.
It's like,
I'm merely attempting to inform them of the power that they have. That's not against the law.
I'm advising you one more time. You may not raise the issue of jury nullification before this jury.
Inform them of the power that they have. I'm not giving them a jury instruction.
I'm telling them about jury nullification. That's what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying.
Yeah, don't mischaracterize.
You just read and said that they have the power. They have the power to do that. So how is informing them?
It's an inherent power that they have. They are not to be instructed on it. That is very clear in the law. Let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell.
Well, let me get some red emojis in the chat. 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 Thank you. Thank you.
They'll wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It never was brought up.
If you
but
think
then when I raised the issue, Your Honor, let me finish.
I'm not prepared to deal with an argument on jury nullification.
I didn't say that's not what I said. That's not what I said. In all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept in there?
So that my clerk could finish
adding a jury instruction that was not there.
76 verdict forms, and it's times 2 because there's a guilty and a not guilty for each. No, let me finish.
So why did I have to sit here for that where I could have just went to my cell and had it delivered?
Not had it delivered.
We had this at the end of last night before you called recess.
I'm not going to debate that topic with you.
We had a whole conversation about
Mr. Brooks.
Me bringing up about the jury nullification,
disregarding this court. You
go
can roll your eyes at me
because
all you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law.
if you would like,
But then I
will
said,
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony may
doesn't.
not have dealt with
It hasn't dealt with closing
the right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is fully applicable.
No, you
because the more
can't change the
general
law,
principle-
Your Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do
practicing
that.
law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So, looking at the Anthony case, all right, and that
The
case
lawful
starting
law.
at head note 7, paragraph 54 says the following.
Yeah,
You
it's gotta
need to
be
let me
some
get
shit.
all the way through it. We have recognized two distinct ways in which a defendant may give up his rights: waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is
She
the
can't say.
intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture: doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We
You like that? You like that, C Cantu? You like my little chibi that I made? Look at his shoes. I changed him. His eyes were farther apart, like the typical little Funko Pop. But I pulled his eyes closer together, and I made his nose a little bit bigger. And don't he look just like the Darrell? And then I was like, ooh, change his shoes to orange slides with white socks under. And Chat GPT did not disappoint. You like it? You like his slides? You like them? Cute. Ooh. It's historically accurate, is it not? Look just like Darrell. Ooh, except for his I gotta figure out a way to do his hairline. I wasn't able to pull that off. That's a harder to command. I don't know how to explain that to Chat GPT. I don't know how to explain it.
Now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly
yeah, that's his blue paperback Bible and his red folder of justice. See his folder of justice. His red folder of freedom.
telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument.
Liz, that is a good point.
That is my ruling.
I object to that ruling, Your Honor.
I'm gonna give Darrell shackles.
Object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect, I'll let you make your record.
I let you make your
didn't interrupt
record.
you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
Requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your Honor,
a court of
because-
appeals, not this court.
No, I'm supposed to be in this admiralty court because if we're under Article 3, then we should be in common law court. That hasn't even been addressed. If we're in a common law court or an admiralty court.
It's the Admiralty.
That's a baseless argument, sir.
We on
I
the
don't
water.
need to
What
address
law
it.
and fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you an opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me.
We got an upgrade to Darrell coming. Let's see if y'all can spot it once I put it up here.
But
Sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your Honor,
the
that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to
circumstances
be
of
fair.
this case and your insistence on arguing jury nullification has resulted in this
haven't.
court
Can y'all spot the change? Can you guys spot the change to the little chippy Darrell? Can y'all spot it?
creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't they be
nullification.
informed of their power?
Because it would violate the Bajirkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how
oral,
I've outlined that
oral
to
motion
date.
for a
I'm
legal
not going
finding
to
of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
Under
interrupt
what
me,
lawful
I was
law?
just thinking
you
that.
will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
See what comes up. Hit the like button for Mama.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
Your objection is noted for the record.
Y'all are in for a treat, honey. Y'all are in for a treat. Okay. Y'all got a treat coming. Okay. Hit the like button. All right. Okay. Hit the like button. Mama got 15 minutes left. She got 15. Wait, no, actually, what time is it? Yeah, we got 15 minutes left in the month of May. You know what I'm saying? Y'all remember Mama is community funded. It's the last 15 minutes of May. Just putting it out there. Oh my God. Will y'all see this shit? Y'all is gonna trip. ChatGPT ain't no fucking joke. Do you hear me? It ain't no joke. This shit is hilarious, bro. Let's see. This is hilarious. This is hilarious, bro. Okay, let's see. Watch this. Look at that bad boy. Look at Darrell in the playhouse, y'all. Darrell in the playhouse. Oh, what y'all think? What y'all think? Oh, shit, Bossy Tuba. Oh, thank you. Thank you, honey pot. Mama appreciate you. Yes, she do. Oh, my first super chat of the night. What might be my only. Thank you, baby. Mama appreciate you. Okay. Yes, she do. Look at Darrell in the playhouse, y'all. Look at Darrell in the playhouse with his shackles. Shackles on his feet. Hilarious, bro. Hilarious. Darrell, look. Look at your photo. Oh, Bossy Tuba. I appreciate that, baby. I really, truly do. I truly, magically do. Ooh. Darrell got teeth knocked out in prison. It seemed like it when he had that one little, when they had that, one of those little virtual meeting things. And he was like this the whole time. Like, and he would talk like this. Hey, I don't know. It seemed like it. It seemed like he was trying to hide his mouth. So, possibly. Good possibility. I can imagine somebody punching him in his face. It just seems like the right thing to do. So, if they did, I support their decision to have done so. I'm sure they had a good reason. I'm sure they had a good reason. I'm sure of it. And if they didn't, I don't care. They, Oh, No, he is done. Doc Evan, he's done. He's cooked. But that doesn't make him any less entertaining, okay? It just don't.
That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling? So is that a tacit agreement that you don't have to answer my objection, Your Honor?
Well, I had a live stream yesterday too, Bossy Tuba. And they was good to mama. I had to do my last 2 days of I had to do the last 2 days. So well, actually I was on the last 3 days. I think I've done like a live stream for the last like 2 days and then today, so 3 days. So yeah. I had coins yesterday. I had lots of coins yesterday. They helped me out yesterday. It was great. But I'm still under my mark. Mama had a bad month. She had a bad month, and that's her own fault. It's her own fault. You know what I'm saying? My inner turmoil is ruining my life.
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
Denied.
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Denied.
Under,
The jury's
based on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
I know, right? Denied. 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 Look at Darrell in the playhouse, y'all.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day.
It's been a long day, Darrell.
First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe.
Mm-hmm.
And
y'all need to be privy,
one thing that I believe that you have not been privy to is the truth of your rights and your duties.
Yeah, you need to know your rights.
Jury.
And
The
your
fact
duties.
that you and you alone have the power. Not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power
to nullify any law that you don't agree with.
Yeah.
Objection, move to strike.
Yeah, like if you guys want to make it legal for me to drive over your children and your grandparents, then y'all can make it so. Y'all got the power. Y'all are very powerful in that way. Daryl, why would they want to use something like that on you anyway? Why? Why would they ever do that?
Statement.
Sustain.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law.
Ooh. Oh, thank you, swimsuit ready. Thank you very much. We have 5 minutes to spare. Well, 10 minutes actually. 10 minutes to spare. Mama, appreciate you. Said jury. The jury. Those videos of me were AI. Trust me. That's Daryl talking to the jury. Those videos, they were AI. Just take my word for it. You just need to learn to accept what I tell you as fact. And you're going to have a happier and more fulfilling life. Thank you, honey pots. Yes. Yes.
The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart.
Yeah, my whole life is on the line, so I decided, you know what? Who is prepared? I ain't gonna be that. I'm not gonna do that. I don't think it's just not me. It's not my style. You know, I like to risk it all. I'm a gambling man. You know what I'm saying? I never know when to hold them or when to fold them. I never walk away when I'm supposed to, and I'm too stupid to know when to run. I would count my money, but I don't have none when I'm sitting at the table. What table? I can't even come in the house. That's the Daryl song. That's terrible, Daryl. That's a terrible story. It's a very true story I just told about you. Okay? It was terrible and it was true. It was both those things at the same time. You never count your money. Ooh. Is he carrying in grapes in his cheeks? Probably. Oh, because of what he be doing with his mouth. I know. Ain't it weird?
In my opening statements, and now I'm going to speak from the heart.
From my heart. Let's speak from the heart. That's when you don't do your homework and you pretend that that's what you were supposed to do.
What you won't hear me do is argue facts. And the reason you won't hear me argue facts,
because you can't,
is because I believe that it takes away from what should be recognized.
Which is?
The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that.
Oh, that's a weird choice, Daryl. I think that's exactly what you were supposed to do. It's the whole point of this. I don't know why you chose to represent yourself if you were not going to do that. But whatever, you know what I'm saying? Keep digging. Keep digging the hole. I know, right? Well done, Daryl. Well done.
It's a little emotional.
There it
I
is.
apologize.
My name is what? My name is who? My name is a little emotional. It's a little emotional. I know it is, Darrell. I know that it is.
For the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year. For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal.
Yeah, it's a lot of people healing after you done ran over them, Darrell. They trying to heal from their wounds.
That opens the door to talk about forgiveness for a little bit. With every healing process,
let's talk about the forgiveness
process.
You know, you gotta learn how to forgive.
It's not an easy thing for anyone.
And learn how to forgive me.
What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it. But they play it so much that eventually you start saying the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it?
That's how Darrell feels about his own song. His own songs. He's like, the fuck is this? Why do I keep singing this horrible, atrocious song? What is this? This song's so shitty, I can smell it. This song is terrible. Oh, Darrell. You supposed to be at the very least, you should be your own biggest fan. You know what I'm saying? It's just,
That's what's been happening. Rerun. Over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. The thing from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? For a year, I've sat and gone through this.
What she was going
feeling
through,
so powerless.
Oh yeah, was you feeling powerless, Darrell? Was you
Letting
feeling
other
powerless?
People run with the narratives.
Running with the narratives. Always with the narratives. Narratives. Ooh, narratives.
Sitting back helpless while other people paint a picture that has zero truth.
It looked like this. Did the picture look
Zero.
like this, Darrell? Was it a picture of you in a playhouse?
I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into.
It's 12 o'clock, y'all. It is now June.
I myself in my own life have had to do a lot of healing. As a man with children myself. I find it hard to believe
He's hurting,
that
Bossy
anyone
Tuba.
who's really
He's in
had conversations
pain.
with me, spent time around me,
It's terrible.
would think for 1 second
Sad.
that this is an intentional act.
Hilarious. I mean, awful.
I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn.
Yeah, you never heard of it? That's news to you, Darrell?
While attempting to alert people of their presence.
Oh, he pulled the tears out. Okay. All right, he pulled his tears out, y'all. He was like, he had to dig around for him, but he got him. I ain't never heard of nobody, honking their horn. And when they was trying to run through people. I ain't never heard of that, You was honking your horn while you was running over the people. It was happening simultaneously, Darrell. You was like, honk, honk, while the people were under the car. So.
Brings me to more information that I believe that you should have been privy to.
Forfeit his whole life.
And I'm sure that
because of attitude,
the prosecution will beg to differ. But the fact of the matter is
what?
The vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact
argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection,
for those model
evidence,
for those model vehicles.
Sustained. The jury will disregard.
The umbilical cord.
Oh, you should have been privy to.
No, he says the umbilical cord. He says the umbilical cord thing in his like after they find him guilty. This is his closing statement, but before the jury comes, before the jury deliberates, and then after they deliberate, come back, find him guilty as fuck. Then they're going to let him do a pre-sentencing speech or whatnots. And that's when he's talking about the umbilical cords that he says he cut. I cut the umbilical cords. That's how I'm a great father, because I cut the umbilical cords. The fact that I do not know how to say the word really brings home the fact that I'm lying my ass off. Look at this. Why does he make this face when he talks?
That you weren't allowed to be privy to. Why? I don't know.
You don't know? Then why bring it up, Darrell? If you don't know, then why'd you bring it up?
Malfunctioning throttle bodies.
Yeah, that malfunction.
It's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is
It's information. It's information.
Hold on. Go ahead.
Move to strike statements by
Sorry
Mr.
for the
Rhodes.
interruption.
Facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained.
How's it a misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you.
They took this from you. You know?
Why?
We in this together. I'm looking out for you, jury. I want you to have all the information that you deserve in this world, which is all the information because you're special. You're special, jury. You're special. That's why I tried to get one of y'all removed for giving me the middle finger. That's why, cause y'all special. Cause I care. She allotted him a whole hour to run his mouth. I don't think he used the whole thing though. He only did for, let's see how long his speech was. Let's see, it was around about the 8:22. And then he finishes. Oh shit. Oh, he almost did it. He did up to 9 o'clock. I mean up to the 9-minute mark. So yeah, so he did about 45 minutes. He used 45 minutes, but she allotted him an hour to do this little closing statement. Yeah, closing statement. This is the closing statement. She allotted him an hour. He used 45 minutes of it. You was facing your whole life in jail and you didn't even use your whole entire hour. Okay, Opera used that whole every single minute of that bitch. Like she had her shit. She came in like it was a full project. Like she had her little things, her little big old things to show. She came prepared to put you underneath this prison. And you come in here talking about, I just want to speak from the heart. You know, I don't want to prepare. And that's why you got 2,000 years. That's why.
Information that you definitely should have been privy to.
You should have been privy. You should have been privy.
DA says the defendant has an utter disregard for human life. Utter disregard for human life.
Oh, there, your homie's leaving. Your homie lover friend is leaving.
Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and born into this world, cut the umbilical cord.
Oh.
Held them before their mom.
I take it back. I guess he did say it in this one. He said the umbilical cord. I cut the umbilical cord. Y'all talking about somebody who was there when their children was born. And that's how you know I didn't ride over them people in the parade, because how you gonna, see your children be born and then drive through a parade? That don't even make sense. Is this you in this car driving through this parade? No, that looks gray. What the fuck does that even mean? They showed him the picture of him in the car driving through the parade in the interrogation room, and they said, "Is this you?" And he said, "No, that's not me. That looks gray." That's what. No, that ain't. That's gray. That's what that is. That's not me. That's way too gray to be me. That, I'm not gray. So no. Got it.
I even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life.
Mm-hmm. Tell us about it, Daryl. Explain it to us.
They made reference to
Ooh,
a
thank
rage,
you, Marianne.
as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, with
Thank you,
rage, what do you mean rage?
Marianne.
How can you characterize that?
How can you characterize that?
How can you have the audacity
Yeah, so audacious.
to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does. DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill.
Mm-hmm. What about it?
And it doesn't kick in until well within blocks.
It don't make any sense. Cause you was bobbing and weaving through this place where you wasn't supposed to be at a high speed. You was bobbing and weaving through there. And as soon as it got to where it got tight, you did the unthinkable. Instead of stopping, trying to find some kind of route that you could get through, you just drove straight over the people and then continue to do it for 8 fucking blocks. Oh, that shit's hilarious. Wow. Talk about victim blaming. Well, when there wasn't so many people in the road, I wasn't hitting nobody. I was driving around them. I only started driving over the people because there wasn't no room, and that's what they get. That was their fault, not mine. That's exactly what he's thinking.
And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years.
All right, Daryl. All right, Daryl. Oh, now Mama is officially tired. I was gonna try to stay up late, but I can feel it in my bone. Oh my God! You know what's so crazy, y'all? I'm gonna tell y'all some real. I'm gonna keep it 100. I don't know what it. Well, I do know what it is. I think it comes with age, but like I get like when I hit my threshold of even slightly tired, suddenly my body and my skin don't fit. Like suddenly it feels like my meat suit, like my skin is not fitting on my body correctly or something, because I suddenly feel like it's like, it's like restless leg syndrome, but all over my body. It's what I feel. Like right now, that's what I feel like. I feel like it's in my back. It's like I can't be comfortable inside my skin, and all I can do is go to sleep. So the only way to fix it is to like lay down. Isn't that weird? Right, back in the day, I could stay up for 48 hours and be straight, like nothing happened. You know what I'm saying? No more. I can't do it no more. Those days are over. Time is a trip. No matter what you do, it just keeps right on rolling. It keeps right on rolling. And waits for no man. Yes. Uh-huh. And that does it for the month of May. That does it for the month of May. For the month of May. Oh, so I'm about to wake up tomorrow. And I'm going to have to make a video. And I'm going to have to post it. I'm going to have to edit it. And I'm going to have to post it. And I'm going to have to be consistent. I have to be consistent. It's so hard. Wrecker's legs. LOL, restless leg. Yeah, it's so weird. I feel it all over my body, though. I feel that, like, it feels like I just can't quite get adjusted. Like my skin is not on my body correctly. All right, y'all. Good night. I'm gonna post a video tomorrow. Y'all gonna watch it. Y'all gonna like it. Y'all gonna if you're not subscribed, I need you to go ahead and subscribe. Okay, we gotta get this thing. We gotta get this thing going. Okay, we gotta get it going. You see what I'm saying? All right, and we're gonna hype the videos. When I post a video, you're gonna like it. You're gonna comment, and you're gonna hype it, and then that thing will be able to get its maximum amount of effectiveness. And I need it. Good night, Marilyn. Good night, Rebecca. Good night, Marianne and Sikantu. Good night, Bossy Tuba. Good night, swimsuit. All right. Later, Gators.